We're about to begin. Good day, and welcome to the Center for States and Children's Bureau overview of PL 113-183, Preventing Sex Trafficking and Strengthening Families Act's Reasonable and Prudent Parenting Standard webinar conference call. Today's conference is being recorded. At this time, I would like to turn the conference over to Christy Stankovich. Please go ahead.
Good afternoon, everyone, and welcome to this afternoon's webinar. Just a few housekeeping items. We are using the GoToWebinar, and in the pane on your right-hand side, you'll notice 5 handouts contributing to today's webinar. Participants are able to ask questions via the chat or questions feature at any time. We'll be addressing those at the end of this webinar. This is a 60-minute webinar, and we will be broadcasting the recording on the Capacity Building Center for States resource page, and we'll be sending a notification as soon as it's available. At this time, I will turn it over to Peter Correa, the Program Area Advisor for Youth Development with the Center for States.
Thank you, Christy. Good afternoon, or good morning to some of you. We have over 425 participants registered for this webinar. How exciting. What a great deal of interest for this topic. We know many of you are invested in the reasonable and prudent parenting standard. Normalcy is something that we all want for children and youth. How we operationalize this is the challenge and opportunity that is before us. Let's see if we can get an idea of who we have attending this webinar today. Christy, could you please queue up the first polling question?
And the polling question is on your screen now. If you'll be so kind to answer promptly, we'll give about 5 more seconds. And we have about 75% of you who voted. I'll go ahead and close the poll in consciousness of time. And we have about 15% of foster care managers who've joined us, 8% of the Chafee ETV coordinators, 2% adoption managers, 6% of state training managers, and the remaining of you have other roles.
I had the opportunity to look at some of those other roles of the people that are pre-registered, and one thing that was really exciting is that they were folks from a real great wealth of different experiences. We had folks on the line from courts, licensing, and a lot of different disciplines that we know all are needed to be able to respond effectively. So that was really exciting to see the many different disciplines, and I know many of you are in that 69%. The format for the webinar that we're going to be going through right now, we have invited a guest panelist from the Children's Bureau, Elizabeth Loevner, to provide an overview of PL 113, in particular the pieces that relate to the reasonable and prudent parenting standards. You'll have opportunities to ask questions. At registration for this webinar, we offered registrants an opportunity to submit questions on this topic in advance, and we did receive some good questions that we will review a bit later. We have also reserved some time after the presentation to ask some questions of our guest presenter. We will also provide an overview of what the Center for States will be offering regarding the RPPS. You will also be hearing from Lynn Wright, the Program Area Advisor for Youth Development with the Center for States, and Matthew Hudson, the Program Area Manager for Youth Development with the Center for States. The slide that you have up front right now is the objectives of the webinar. And the objectives of the webinar are to assist states in building the capacity to plan and implement reasonable and prudent parenting standards provision of the new law, provide an overview of the legislation highlighting the RPPS provisions, introduce the requirements and point out the associated timelines, and finally we will provide a preview of a few of the forthcoming resources and additional webinars and information available from the Center for States. It is my pleasure right now to introduce our guest panelists. We are very fortunate to have Elizabeth Loevner as our guest panelist today to speak with us about Public Law 113-183. Elizabeth is a child welfare program specialist in the Policy Division of the Department of Health and Human Services Administration on Children and Families. Elizabeth, thank you for taking the time to be with us today and share your expertise.
Hi, everyone, and thank you very much for that great introduction. My name is Elizabeth Loevner. I've worked in the Policy Division at the Children's Bureau since about 2007. And if you aren't aware already, our role is generally drafting regulations, providing technical assistance on draft legislation, interpreting and providing guidance on that legislation, and generally to provide day-to-day policy guidance on Children's Bureau programs. We also provide support to the regional offices in providing assistance and guidance to states and tribes. So you have that general background. I'll jump into this overview of 113-183, the Preventing Sex Trafficking and Strengthening Families Act. I assume that most of you, if not all of you, are familiar with the law, and you may have even heard a version of this presentation at one point in the past. So I'm going to provide a general overview with a focus on the reasonable and prudent parenting standard. I'm also going to try to pause and focus a little more on other areas of interest that were indicated by your pre-submitted questions. So this presentation is divided up by effective dates. So I'll start with these provisions that are effective upon enactment. So I'll go to the next slide. And talking about the Title IV Adoption Assistance Program savings reporting requirement. I won't spend a lot of time on this. This goes back to 2008 when Fostering Connections created a requirement for 4E agencies to spend savings from delinking the 4E Adoption Assistance Program from AFDC requirements on child welfare services. So now there's some specific requirements around calculating the savings and reporting that to us. We recently issued a PI 1506, that provides specific instruction on the adoption savings calculation methodology. That's all there, so I'll let you look there if you have more interest in that, or of course always contact your regional office. The next provision is the relative notification and sibling definition provisions. These modify some requirements added by Fostering Connections as well, and that's on the next slide, I apologize. So it includes the parents of a child's siblings in this relative notification provision, and it also adds a definition of sibling. It basically references back to what the state law is, and that's all contained pretty simply in the law. We're cited here in the Social Security Act. On the next slide, we'll talk about the successor guardian provision. This amends the existing Title IVe Guardianship Assistance Program to allow a successor guardian if the guardian dies or is incapacitated, as long as that successor is named in the Guardianship Assistance Agreement. We've issued several child welfare policy manual questions on successor guardianships, and I'm sure there's going to be more to come, hint, hint. For the states, I really do hope you continue to submit your questions to your regional office. I know many were submitted today that we may discuss later. The regional offices can work with you on resolving these issues, and if needed, they'll contact us, and it's always great for us to hear what issues you're struggling with, and hopefully we can help resolve them. On the next slide, I'm just going to mention the Family Connection Grants Program. It was reauthorized, and they also made some small changes to this program. This is another program established by Fostering Connections that's basically being updated in this law. So now I'll move on to the next slide, and I hope that you all will have a chance to look at these slides if you have more questions about the specific provisions. But these are about, the next section is about provisions that are effective a bit later, 1 year or later after the enactment of the law. So this is including the provisions you're most interested in hearing about today, I'm sure, which is the reasonable and prudent parenting standard, and the requirements around reporting children missing from care, some other requirements around older youth. So on the next slide, first discusses the requirements around victims of sex trafficking. So this law created a Title IVe plan requirement
that 4A agencies have to develop and implement procedures to identify, document, and determine appropriate services for a specific group of children who are at risk of becoming a sex trafficking victim or who are already a sex trafficking victim. Agencies are also required to report the number of children and youth who they've identified as sex trafficking victims to HHS each year. On the next slide, we lay out who is considered a child under this requirement. It's not just anyone under 18. It actually includes any child in the placement and care and responsibility of the agency, and that includes any child who's not removed from the home but has an open case file. It includes children under age 18 or who have run away from foster care, and that also includes those children who are up to age 21, depending on when a state or tribe elects to extend 4E. It includes those children who are not in foster care but who are receiving CHAFE foster care independence services. And at the option of the state, this could include anyone under age 26, even if they were never in foster care. This is a phased implementation. Within 1 year, agencies have to develop procedures. Within 2 years, they have to demonstrate implementation of those procedures. And within 3 years, they need to start reporting those total numbers about the number of children who are trafficked to HHS. And on the next slide, I just mentioned really quickly that one of the other definitions is of sex trafficking victim. That just references to the Trafficking Victims Protection Act. And I won't linger on that, so we'll go to the next slide and talk about this new provision related to locating children who are missing from foster care. It requires Title IV agencies to develop and implement protocols to locate children who are missing from foster care. And it also requires them to gather some information in determining the factors that led to the child being absent from care, to determine the child's experiences while they were absent from care, including whether they were a sex trafficking victim, and then, of course, collect that information and report it to HHS as we require it. And that goes into effect within 1 year of enactment, so coming up very soon. On the next slide, I talk about the new requirement for 4A agencies to report sex trafficking victims and missing and abducted children to law enforcement. So more specifically, agencies are going to be required to report children who are identified as being a victim of sex trafficking to law enforcement within 24 hours. Agencies are also required to report information about missing or abducted children from foster care within 24 hours to law enforcement for entry into the NCIC. Agencies are also required to report these children to the National Center for Missing and Exploited Children. I do want to mention here something it's not our specific guidance, but I think might be helpful for you as you think about how to implement this requirement around the National Center for Missing and Exploited Children, which is that they have launched a site dedicated to children missing from foster care. That can be accessed on their webpage at missingkids.org, and it will include resources for states and others around children missing from foster care. And very soon, hopefully, it will include an online reporting mechanism for state and tribal agencies to use to report these children to the National Center as required under this law. All right. On the next slide, I'm just giving a little reminder that children in this context, around these requirements to report sex trafficking victims and missing children to law enforcement and the National Center, it doesn't just include everyone under a certain age. It's, again, this broader definition that includes all the children in the placement and care of the agency, including those who are removed from home but have an open case file, those who've run away, and those who are not in foster care but are receiving CHAFE services. Okay, on the next slide, I'm going to go into the new requirements that create limitations on another planned permanent living arrangement as a permanency goal. And I'll refer to this as OPLA, but this is also known as long-term foster care. The new limitation is that OPLA can only be a permanency plan goal for youth who are age 16 or older. And tribal Title IV agencies actually get a couple more years to implement this limit. As you know, this is already restricted to when other permanency options have been ruled out. But they actually created some more requirements around what needs to be documented and done when OPLA is a requirement for youth age 16 or older. So as I mentioned, this is only for youth 16 and older. And for children who have this permanency plan at OPLA, the agency has to document the efforts to place the child permanently with a parent, relative, or in a guardianship or adoptive placement at each permanency hearing. And this is similar to the existing requirements around documenting a compelling reason for OPLA. What I want to note here is a little bit of guidance that's not on this page, but that I believe we've issued around when this is really effective. And that means that this is going to need to be met in the next permanency hearing for any child who's going to have a goal of OPLA. So in the next permanency hearing, this will need to be met. And also, if a child is under 16 and is about to have their permanency hearing after the effective date of the law, and their permanency plan is going to need to be changed from OPLA if it is currently OPLA. So basically this goes into effect, I believe, 1 year after the effective date, so at the end of September. But really, for each individual child, this is going to be coming up in their permanency hearings when these changes need to be made. And on the next page, I talk a little bit more about the requirements at each permanency hearing now for children with a goal of OPLA. The court is going to have to ask them about the permanency option, their desired permanency outcome, and make a judicial determination that OPLA is the best plan. They're going to need to have a judicial determination that for compelling reasons why it's not in the best interest of the child to be placed permanently with a parent, relative, or in a guardianship or adoptive placement. And again, this is a requirement similar to the existing judicial determination requirements in law. And on the next slide, there's a requirement for the Title IV agency to document how they're ensuring how the reasonable and prudent parent standard is how they're taking steps to ensure that that's being followed to allow the child who has the goal of OPLA to have regular opportunities to engage in age or developmentally appropriate activities. And this has to be done at each permanency hearing and at each periodic review. So this is a link into the reasonable and prudent parenting standard, but there's an extra piece of the agency needing to assure that they're showing that this is being followed. And speaking of the reasonable and prudent parent standard, which is the reason for this webinar, the law, this is on the next slide, the law established requirements. Oh, wait, before we go into that, we're going to have a poll, it looks like. I guess I'll go ahead and talk us through the poll. And that question is, does your state have a policy or something similar in place as a requirement for the reasonable and prudent parenting standard already?
We have about 50% response rate, and we'll wait maybe 5 more seconds in consciousness of time. And at this time, I'll close the poll. results are 49% yes and 51% no, with 63% of you responding. So thank you.
Yes, thank you, everyone. That's really interesting to see. So that means if you already have something like this in place, you get a chance to take a second look at how it is implemented and see if it meets the minimum federal standards. And if you don't, well, here's a chance to put that in place and start from scratch and think about how you want to implement that in your state. So the law established some requirements around a reasonable and prudent parenting standard, which is basically a standard to allow foster parents and designated officials at child care institutions to make decisions to allow a child to participate in extracurricular, cultural, and social activities. Basically, the reasonable and prudent parenting standard is there to allow foster parents to make decisions that encourage normalcy. And on the next slide, I'm going to talk about what the specific requirements on the Title IV agencies are. And that is that the Title IV agency requires that the licensing authority allow the use of the reasonable and prudent parenting standard, and that it requires child care institutions to have an official authorized to apply that standard. There are also some requirements around training to ensure that foster parents and these authorized officials have the training they need to actually apply the standard correctly and have the skills and understanding of how to apply it. HHS is also required to provide technical assistance on best practices to help foster parents in applying the reasonable and prudent parenting standard. We've issued a question and answer on the reasonable and prudent parenting standard in the Child Welfare Policy Manual, and I'm sure we'll have more on the way. We've also provided instruction in PI 1507 for the Title IV Plan Submission Reasonable and Prudent Parenting Standard. Just to mention that QA, since this is the Reasonable and Prudent Parenting Standard a presentation, what I want to mention there is that the QA really asks about whether the standard must be included in the foster care licensing standards in each state. The answer to that is yes, it must be. And it asks whether foster parents and the child care institution designated official must apply it. And the answer to that is yes as well. Okay, so next we're going to move on to the new Title IV-E and IV-B requirements for children age 14 and older. So the law adds a few new requirements for young people age 14 and older, including that the agency is going to have to document the child's rights and that the child was provided the rights in the case plan. And they have to develop the case plan with the child and at the option of the child, 2 members of the case planning team. It also amends existing requirements for describing transition requirements and providing a copy of the child's credit report to apply them starting at age 14 rather than age 16. And on the next slide, we talk about this new requirement that the 4B and 4A agency provide a youth aging out of foster care at age 18 or the older age up to 21 as elected by the agency under the Title IV-E plan to extend foster care, with these important documents, including a birth certificate, a Social Security card, a driver's license or identification card, health insurance information, and medical records. So you need to provide these to all youth who are aging out of foster care, except for those who have been in foster care less than 6 months at the time they're aging out. And on the next slide, I'm just going to mention very briefly some new requirements around AFCARs. 4E agencies are going to be required to report information on children in foster care who've been identified as a sex trafficking victim, both if it was before entering foster care or if they were victimized while in foster care. And also need to report information on the number of children who entered after a finalized adoption or legal guardianship. We addressed these in the AFCARs Interim that was published back in February of 2015, and collection on these items wouldn't start until after we publish a final rule. And unfortunately, I don't have a date for when that would be. All right, and the next page I'll just mention really quickly the expanded purpose of the Chafee Foster Care Independence Program. The purpose now includes ensuring that children who are likely to remain in foster care until age 18 have ongoing opportunities to engage in age or developmentally appropriate activities. And this ties back to the reasonable and prudent parenting standard to ensure the opportunity for normalcy for these children. The law also bumped up the appropriation for the program by $3 million, but not until fiscal year 2020. And the next slide, I'm not going to spend a lot of time on this, but briefly I'll mention that the law revised the Adoption Incentive Program to generally create some new incentives for guardianships, create some other new categories for awards, and allow states 36 months rather than 24 months to spend that award amount. And in my final group of slides summarizing these requirements, I'm going to note some requirements the law creates for us for HHS. So you may be familiar with the Child Welfare Outcomes Report on this next slide. The law adds some additional data that we're going to have to provide, including data on the number of children who are in foster care who are pregnant or parenting. And interestingly enough, in the AFCARS Imperium, we actually proposed to collect data on children in foster care who are pregnant. And we're going to be required to include data on children who are placed in a child care institution or other non-foster family home setting. So we need to include in this report the number of children in the placement, their ages, whether they have a permanency plan of OPLA, the duration of the placement and the type of child care institution, the number of foster children in each setting, and any clinically diagnosed special need of the children in those settings, and the extent of special education or services provided in the placement. This is all getting at more information around OPLA and around those non-foster family home settings. On the next slide, I'll just briefly mention that HHS is also going to be required to report to Congress on the number of children who are running away from foster care and their risks of being a sex trafficking victim, their characteristics, the factors associated with running away, their experiences while absent from care, among other things. And also agencies' implementation of and best practices for the case planning amendments related to OPLA and the requirements for children aged 14 and older. So this ties back into those requirements that I discussed earlier, and we are going to be determining our approach for gathering this information, and we'll provide additional information on what we'll be asking for states a little bit later at that time. And I should also mention that these reports aren't due until September 2016 and September 2017. And finally, HHS is required to appoint a National Advisory Committee on Sex Trafficking of Children and Youth in the United States to advise on practical and general policies to improve the national response to sex trafficking and develop best practices. So now that I've given you the brief rundown of everything that's in 113-183, I'm going to give you some information on the guidance we've provided and a list of resources for more information on the law. And some of these will have links in them, and I hope you'll be able to get a copy of the presentation afterwards and be able to click through if you need to. So here's a list of all of the program instructions and information memoranda that have come out of our central office. We have 1403, IM 1403, which gives you a broad summary of the law, PI 1406, which gives you guidance on relative notification, the sibling definition, and successor guardian provisions. PI 1503 and 1504, that's all about the submission of the APSR and includes the updates that were needed based on 113-183. PI 1506, that's the one about the adoption savings calculation methodology. and PI 1507, which provides instruction on the changes to the Title IV plan requirements that are effective in on September 29, 2015 or later. And it provides an updated Title IV preprint that has information on the reasonable and prudent parenting standard, the OPLA requirements, the requirements related to children missing from care, and many more. Another place that we provide guidance is through the Child Welfare Policy Manual. And so on the next slide, I'm just talking about the Child Welfare Policy Manual updates we've made since the publication of the law. And we've had some on topics like successor guardians, reasonable and prudent parenting standard, the OPLA requirements, the requirement around foster child rights, and the requirements for providing important documents to youth who are leaving foster care. Look for more QAs in the coming months as we go forward. These are all distributed through our listservs, to our regional offices, and can always be found on the CV website. And there is actually a place to click through on the Child Welfare Policy Manual site where you can see all the new questions that have been recently added. And my last slide is going to just give you the list of resources of the URLs for our Children's Bureau website, for the Child Welfare Policy Manual, which is a great resource, for those program instructions and information memoranda, if you want to take a look at those and haven't gotten a copy or retained a copy of them. I'm giving you my email, so feel free to reach out to me. But I also want to let you know that on the CV website, and I also believe in the handouts for today, you will find contact information for your regional offices. And they're a great place to reach out if you have questions about any of these provisions and how you're implementing, and can give you lots of support. And they will reach out, of course, to the policy division if they need our assistance. But they've got a lot of great information and guidance to provide you as well. And with that, I think I will hand it back over to the Capacity Building Center, or are we going to do QAs right now? Sorry.
Yes, Elizabeth, this is Lynn Wright, and thank you very much for that presentation. We are going to go into the Q&A. What you see on the screen right now are some of the questions that came in at registration. We asked for registrants to submit some of the questions they had before we did the webinar, and these are some that came up. So if you wanted to address some of these, I thought it would be a good idea in the meantime for Christy to share with our participants how they can be submitting their questions to you right now. And while they're doing that, then you could be addressing those questions. Christy, would you like to share?
Of course. As you can see on your screen, to submit questions, you can go to your GoToWebinar pane on the right-hand side. In the questions pane, you may address your question, and we will submit it for Elizabeth to review, and we will be answering promptly. If we cannot get your answer today, we will be addressing following today.
Okay, great. So some of these I'm not going to have a great answer for you today. This is just the start of a lot of this assistance, so we'll just go through these one by one. The first question is asking about guidance that exists for states on the policy and training provisions related to reasonable and prudent parenting. I mentioned today that we have some questions already up and more to come on the Child Welfare Policy Manual around the policy requirements on this. But a lot of the implementation for this, a lot of the information on implementation of this and the guidance for that is going to come from other sources. The next question is about what funds should be used to pay for activities associated with the reasonable and prudent parenting standard. And again, this is an area where I believe we will anticipate providing some guidance on in the future about what specific activities can be allowable. A good place to go and look right now is in the Child Welfare Policy Manual, where we talk about what sort of administrative costs are allowed under Title IV-E and what would not be a Title IV-E allowable cost. And also, will there be examples of how to implement the prudent parenting into policies and procedures? Again, this may not be coming directly from us in policy, but I do think that that will be coming out of the ongoing guidance and discussion and technical assistance that you'll be receiving. One of the questions that we did receive that are not on this page was a question about successor guardian requirement. It was asking if there was an unexpected death or disability of the guardian, and then could the agency amend the agreement after that death or disability to add a different successor guardian if that one's not available, or to add a new successor guardian? And generally, the answer to that is no, that the successor guardian has to be named in the agreement. And while the agreement can be amended at any time, it could not be amended after the death or incapacity of the guardian. So that needs to be taken care of early on, and should be something that's in the process right now that states are doing. And I believe we've also answered that there's no limit to the number of guardians in the statute that can be named as successor guardians. So if that's a concern, a state is certainly welcome to name multiple successor guardians in the agreement if they're concerned about the successor guardian not being available. And do we have some questions coming in? Apologize here.
We have some questions that are asking about access to the materials today. And so while you're looking at the policy questions, Elizabeth, I'll share with our participants that, yes, you will have access to the PowerPoint and the Children's Bureau PI and Information Memorandum. We have posted some up in your in the handouts in the section. If you'll click on your red arrow and pull the menu out, you can see that there are some links there that you can actually click on and access those right now from this webinar. And there we have 3 of the Children's Bureau guidance. We also have the list of the regional officers, the current list of how to contact your regional office. And then we have the overview of the legislation, which is the PowerPoint today. So while Elizabeth is looking at the questions to see how she can respond, if you want to try to access those right now. And if there are any other materials, we can post those on some of our websites. We'll also be showing you how to access our micro website a little bit later on.
Okay, so I'm going to go ahead and start going through these questions. Some of them I think I'll be able to answer, and some of them I might not be able to today, but we will get to those hopefully later and be able to address them later for you. So the first question is, isn't the requirement for law enforcement to report to NCMEC? And the answer to that is no. The requirement is for law enforcement to report to the NCIC, and that is, of course, because there's limited access to the NCIC. The agency is required to report to the National Center. There's a few questions around liability. We have not issued any guidance around the liability issue. There's, of course, existing policy talking about liability insurance and when if it can be paid for under Title 4E in the manual. And we're aware that there are a lot of questions out there about what the liability requirement around the reasonable and prudent parenting standard is. So continue to submit those here today and to your regional offices, and we will see if there's going to be if we will be able to issue some guidance to clear some of that up. One of the questions is driving considered an age-appropriate activity? Generally, I could say that that's going to be something the state is going to need to determine themselves. Does the child care institution need to apply the prudent parenting standard to all children, or only those in the custody of the state? I'll have to get back to you on that one because it's really around the licensing requirements. So I'll definitely take that one back. So here's one. You said that for children under 16 years old that currently have an OPLA goal, will have will have until the child's next permanency hearing to change the goal to another permanency goal. And that's correct. So at the next permanency hearing, the child is under age 16 after the effective date. The next permanency hearing is when the goal needs to be changed. And as I mentioned before, yes, the successor guardian needs to be named in the agreement prior to the existing guardian's death or incapacity. And there is that option if states want to name multiple guardians to have a few options in case of the death or incapacity of the original guardian. And yes, states. One of the questions is, do states need to change any current OPLA to something other than OPLA for children under age 16? And the answer to that question is yes. This is effective for all children, regardless of when they entered foster care, and when that goal needs to be officially changed in the next scheduled permanency hearing for that child. So going forward, every child who has a permanency hearing, if they're under 16, they should not have a goal of OPLA. There's one question about successor guardians need to be fully approved or licensed before receiving the guardianship subsidy. Successor guardians do still need to meet some requirements. Very important to those is the background check requirements need to be met prior to that child getting a Title IV payment, regardless of whether it's a successor guardian named or not. And some of these questions, I think, some of these are really great questions, and unfortunately I'm not going to be able to answer all of them today. I hope I've been able to give you a little bit of assistance. Definitely take some of these back and try to get responses for everyone. And as our guidance comes out that's official too, we'll try to make sure that everyone who's been on this webinar today gets a copy of that email that goes out. So with that, I think unless there's some more new questions coming in, that's about all I can answer today.
Okay. Well, thank you very much, Elizabeth. We wanted to share with you a little bit about what the Capacity Building Center, how the center can assist. And but before we do that, we have one more polling question we'd like to launch. We wanted to learn a little bit about what support you need for implementing the reasonable and prudent parenting standard provisions of this law. So if you could select all that apply here.
And if you've selected other, please provide that in the questions or chat pane. We have about a 60% response rate, so we'll wait maybe 5 to 10 more seconds. And I'll go ahead and close the polls at this time. And we have 68% peer-to-peer networking and sharing, 82% identification of state programs and policies, 34% on-site technical assistance, and 14% other.
And did we have anyone write in what the other might be?
We do have a few guidance of liability coverage for foster homes and child care institutions.
Great. And this is Matt Hudson, Program Area Manager for Youth Development with the Center for States. And I want to talk a little bit about what you can kind of then expect coming forward in terms of assistance from the center. So the first thing is that we're going to have a follow-up webinar to this webinar. It's going to be on October 7th at 1 o'clock Eastern Time, so noon Central, 11 o'clock a.m. Mountain Time, 10 o'clock a.m. Pacific Time. It's going to be a follow-up to this. We're going to get a little more into detail about some of the more practical aspects of normalcy. We're going to talk a little bit about some of the information that was discussed at the White House Summit on Developmentally Appropriate Services for Youth and Young Adults in Foster Care, which happened in May, and was breakout sessions and conversation about how to implement these RPPS normalcy provisions of PL 113183. And so we definitely would like for all of you to be on the lookout for an invitation coming soon to attend that webinar as well, where we can talk about some of those things, and we can try, based on what we've heard today, to maybe have a discussion even around liability, but that does get a little complicated. However, also things to look forward to, and on the next webinar we'll be announcing what we expect the dates for these to be available are, but we're going to have resources or products available that are intended to help with some of these aspects. So we intend to have a guide that will help with reproducing a summit like the one that was held with DC in your state. It will include topics to discuss, who involved in your state child welfare system should be there, including youth, including foster families, who you might contact to get assistants or consultants to come into your state to help you do those things. We are putting together lists of model programs from across the country that can help with some of these provisions, as well as trying to aggregate some of the state policies that other states have. This is pretty new for everyone, so there's really only a few states that have kind of a couple of years of experience behind a policy like this. I can tell you Florida and California, Indiana are who we have been looking at, but there are other states that are currently developing them, and so we're trying to get those together for anybody who might need those as well. Then we're also looking at, there's actually a requirement inside of PL 113183 for there to be a list of rights provided to the young people. And so we are working on gathering information and offering a tool for what Bill of Rights across the country look like and what should be included in them. And then along with that is information on how states can go about utilizing or congregating youth advisory boards. Particularly, we are looking into what can be done so that our youth advisory boards that exist in states being used when a youth who's been given a Bill of Rights feels like they have had a right violated. So we're going to get into some a little bit more than just here's what, say, a youth advisory board is, but more how can they be used to be effective in what we're being told needs to come from PL 113183. I think, too, for the person who said other and then mentioned information on the liability, I think some of that is probably going to come with state policies as we find examples of those. At the White House Summit, that was discussed. So I think that that's something, like I mentioned before, we'll try to maybe discuss on our next webinar and highlight when we gather state policies for what those states have done to address that issue of potential liability with foster parents allowing youth to participate in certain activities. So I know that it's kind of like spoiler alert, these things are coming. If you'd like more information, we definitely encourage you to join our next webinar on October 7th at 1 o'clock Eastern Time. Thanks.
Thank you, Matt. If we can look at the next slide, which will talk about some of the what's available on the handout that Lynn talked to you about, the red tab on the side. These are the pieces of information that are available to you. I want you to also know that the recording will also be available to you at sometime shortly. So that's another piece. The other what we want to talk about is the contact us slide, which would come up. This is the Center for States Capacity Building website, please go to the website and get information there. That's readily available to you all. There will be more information coming at a later date, as Matt was talking about the products that are being developed. The next slide, we'll talk about the group that's working together on this. It's a great team of folks working on this. These are the contact people you'll see here. You heard from Matt today, myself, Lynn, Melissa, and Joan are also folks that we're working with together on looking at this whole process as we develop resources that meet your needs. And then the two Children's Bureau contact leads, or program officer leads on that, is Catherine and Taffy. This is the group that we're working with some other folks that are driving what the next webinar will also be looking like, based also on your recommendations that we get from this webinar today. So with that, I want to thank you all for participating in the webinar today and look forward to your attendance at the October webinar. We will do our best to assist in the identification and facilitation of best practices and sharing of ideas and information on the subject. Thank you again and have a great afternoon.